Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video we are going to discuss preliminary exam paper of Andhra Pradesh Judicial Services 2024. I hope कि ये वीडियोस आपके लिए बड़ी यूजफुल रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही बेनिफिशियल रहेगा. एंड अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel, and while subscribing don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. So don't forget to give us a super thanks. So let's move to the questions. Question number 1 is, with reference to provision of section 38 of CPC, select the correct statement. A decree may be executed only by the court which passed it. नहीं, either by the court which passed it or by the court to which it is sent for execution. तो 4 इसमें आंसर रहेगा, सेक्शन बता ही दिया. 4 will be the answer and section is already mentioned. Next question number 2. With reference to Order 21 of CPC, read the following statement and select the correct option. For decree of payment of money, the court may pass an order for immediate execution thereof, even on oral application of decree holder. Means, if any person, a decree holder, goes to the court and files an oral application and say the court that I want my money back, I want to file execution, the court may allow it on oral application. This is correct. This is correct. Then B is, except for a decree of payment of money, every application for execution of a decree shall be in writing. This is also correct. This is mentioned in Order 21, Rule 11, and this is segment B is Subrule 2. So both are correct. 4 is the answer. Next is 3. With reference to Order 38, arrest and attachment before judgment, select the correct options. Small cause court cannot attach immovable property. This is correct. Attachment before judgment shall also affect rights of strangers. No, this is wrong. Agriculture produce in possession of agriculturist is also liable to attachment. This is wrong again. Section 60 में mention किए हुए सारी which things you can attach, which cannot. Attachment shall continue even after furnishing security by defendant. The court will cancel it. So the correct answer is 1. 1 is the answer. Next is 4. Provision of inherent power of court is stated in section. Everybody knows 151.3 is the answer. It's extremely common question and always repeated question. Next is 5. Which order and rule of CPC states processes served on a recognized agent or party shall be factual as if the same had been served on the party in person unless the court otherwise directs? Order 3, but which rule? 1, 4 or 3? It is rule 3. 1 is the answer. Next 6. The maximum time limit to file a written statement under second proviso of Order 8 Rule 1 with payment of such cost as the court deems fit is 120 days. 2 is the answer. See, the normally is 30 days, extension of 30 days, and extension can be given up to 90 days. Alright, and with the cost it may allow up to 120 days. After it is not allowed. So 2 is the answer. Next is 7. As per CPC, no objection as to place of suing shall be allowed by the appellate or revisional court unless the objection was taken in the court of first instance at the earliest possible opportunity. This is mentioned in section 21. 15 days, 30 days before pronouncement. Now 1 is the answer. Next is 8. As per section 102 of CPC, no second appeal shall lie from any decree when the subject matter of the original suit is for money not exceeding 50,000, 40,000, 25,000, 75,000. It is 25,000. 3 is the answer. Section is already mentioned here. Next is 9. The power of revision under section 401 of CRPC can be exercised by Who can exercise? It's a High Court. 3 is the answer. Now in new Bharatiya Nagrik Suraksha Sanhita, section has become, it is now section 442. Next is 10. The power of appellate court are laid down in which section? It is in section 386 of CRPC. 1 is the answer. Now in Bharatiya Nagrik Suraksha Sanhita, this section has become section 427. Alright. Next is 11. With reference to CRPC, select the incorrect option. Every charge shall state the offence with which the accused is charged. This is correct. The law and section of law against which offence is said to have been committed shall be mentioned in the charge. This is also correct. Charge may be in writing in any language, no language of court. So this is incorrect. The fact with date and place of previous conviction of accused, if any, shall stated in the charge. This is also correct. So 3 is the answer. The contents of charge as mentioned in section 211 of CRPC. Now in Bharatiya Nagrik Suraksha Sanhita, this section has become 234. Next is 12. Power to suspend or remit sentence under section 432 of CRPC lies with the appropriate government. 4 is the answer. Now in Bharatiya Nagrik Suraksha Sanhita, this section has become 473. Next 13. Under which section of CRPC can information in cognizance case FIR be filed? Everybody knows this 154. Very easy question. 1 is the answer. Now in Bharatiya Nagrik Suraksha Sanhita, it is 173. New section. Next is 14. Supreme Court of India in Union of India versus Ashok Kumar Sharma in 2020 clarified on, the case was on 0 FIR. 4 is the answer. Next is 15. Whom the following is empowered under CRPC to pass an order for execution of a bond for keeping peace and good behavior by a habitual offender? So see, there is a sequence of this and I have mentioned in many of my videos. So you can make it like this. This is section 106, 107, 108, 109 and 110. Okay, you can make chart like this. So here it is for 3 year, 3 year. In all is 1 year. This is 110 is for habitual offender. 106 is by the judicial magistrate and all others by the executive magistrate, EM, and EM. So you can learn it like this. Okay, you can mention the sections yourself in this particular part, for which it is judicial magistrate takes the bond for keeping peace, good behavior for normal person, and here habitual offender. All right. This answer is to executive magistrate. Now in Bharatiya Nagrik Suraksha Sanhita, this section has become 125 to 129 in Bharatiya Nagrik Suraksha Sanhita. Alright. Next is 16. With reference to section 219 of CRPC, select the most appropriate option to fill in the blanks. So 3 offences of same kind within 1 year may be charged together. So 3 is the answer. Very easy question. Now in Bharatiya Nagrik Suraksha Sanhita, this 3 has become 5 and 12 months period. And section has been changed to 242. Next is 17. As per section 262 CRPC, the maximum sentence that can be passed under summary trial is 3 months. 4 is the answer. Section has become 283 in Bharatiya Nagrik Suraksha Sanhita. This is 18. Under section 166A of CRPC, a letter to competent authority for investigation in country or place outside India is called letter rogatory. 1 is the answer. Now in Bharatiya Nagrik Suraksha Sanhita, the section has become 112. Next is 19. A and B agree to fence with each other for amusement. In the course of fencing, A, while playing fairly, hurts B. With reference to section 87 of IPC, select the correct option. A had committed no offense, obviously. Whenever the good faith comes in picture, you mention here na, fairly means in a good faith. It can be no offense. A has committed no offense. One is the answer, and this is illustration in section 87. This section 87 has now become section 25 in Bharatiya Nyaya Sanhita, new IPC. Next is 20. As per section 82 of IPC, nothing that is done by a child under age of 7 years is an offense. One is the answer. It is also called as doli incapax, means incapacity of a child. All right. Now the section has become section 20 in Bharatiya Nyaya Sanhita. Next is question number 21. Section 376D deals with offense of gang rape. 4 is the answer. Now the section is section 70 in Bharatiya Nyaya Sanhita. Next is 22. The offense of voluntary causing grievous hurt by use of acid attack was added to IPC by the Criminal Amendment of 2013. 1 is the answer. The section was 326AB. All right. Now the section has become section 124 in Bharatiya Nyaya Sanhita. Next 23. With reference to IPC, read the illustration and select the correct options. A, obstruct a path along with Z has the right to pass. A, not believing in good faith that he has right to stop the path. A is thereby prevented from passing. With reference to IPC, what offense, if any, has A committed? He has committed wrongful restraint against Z. 3 is the answer. This is illustration in section 339 of IPC. In new IPC means Bharatiya Nyaya Sanhita. Section is now 126 and this is illustration in that section. Next is 24. Section 370 IPC deals with the offense of trafficking of a person. 2 is the answer. Procuration of minor girl is mentioned in section in 366A of IPC. Unlawful compulsory labor 374, habitual dealing in slaves 371. Now in new IPC, section 370 has become section 143. The procuration of minor girl is now section 96. Unlawful compulsory labor is now 146 and habitual dealing in slaves 145 in Bharatiya Nyaya Sanhita. Next is 25. Which of the following is not covered under punishment as per section 53 of IPC? Forfeiture of property is there, yes. Fine is there. Community service is not there. Simple short punishment, yes. So 3 is the answer. Now the punishments are mentioned in section 4 and community services has been added to that punishment in Bharatiya Nyaya Sanhita. Next is question number 26. As per IPC, monitoring the use by a woman of internet, emails or any other form of electronic communication amounts to the offense of stalking, voyeurism, cruelty, harassment. It is stalking. 1 is the answer. का मेंशन किया गया इन सेक्शन 354D में. अब इन भारतीय न्याय संहिता में हो गया सेक्शन 78. Okay. Next is 27. As per section 393 of IPC, whoever dash to commit robbery shall be punished. Makes preparation, attempt, has motive, has conspired. Section 393 relates to attempt to commit robbery. 2 is the answer. Now this section has become 312 in Bharatiya Nyaya Sanhita. Robbery has become section 309 in new IPC, मतलब Bharatiya Nyaya Sanhita. Next 28. As per section 29 of IPC, the word document denotes any matter expressed or described upon any substance by means of dash and intended to be used, which may be used as evidence. Letter, figures, marks, or more than one of these means. 4 is the answer. Now in Bharatiya Nyaya Sanhita, it is in definition section 2 subsection 8. Next 29, a criminal act that was result of voluntary bodily movement is known as, it is mens rea, res ipsa loquitur, or actus reus. It is actus reus. 3 is the answer. What is res ipsa loquitur? Things speaks for itself. Next is 30. A is accused before the court of session for attempting to murder a police officer whilst on trial before B. A session judge may be examined as to what occurred. B shall not be examined, can be examined only upon the order of Chief Justice of High Court. B has option to be examined or not. May be examined as to what occurred. So 1 is the answer. This is mentioned in illustration C in section 121 Indian Evidence Act. Now in Bharatiya Sakshya Adhiniyam BSA, this section has become section 127. Next is 31. With reference to the Indian Evidence Act, read the following statement and select the correct option. In a civil case, the fact that the character of any person concerned is such as to render probable improbable any conduct imputed to him is relevant. This is correct. This is mentioned in section 52 of Indian Evidence Act. Next is B. In criminal proceeding, the fact that person accused of good character is irrelevant. No, it is relevant. It is mentioned in section 53. So A is correct, B is incorrect. 1 is the answer. You need to see that it is mentioned in civil cases. Therefore, this statement is wrong. However, in criminal cases, it is mentioned in section 52 of Indian Evidence Act. Next is B. In criminal proceeding, the fact that a person accused is of good character is irrelevant. Now, the good character is relevant in criminal proceedings. This is also incorrect, mentioned in section 53 of Indian Evidence Act. So, both are incorrect. 4 is the answer. Now, in Bharatiya Sakshya Adhiniyam, 52 has become 46 and this is 47. Next is 32. Section 112 of Indian Evidence Act deals with, किसे deal करता है? It deals with the presumption of paternity, है ना? तो but during marriage conclusive proof of legitimacy. 3 is the answer. Presumption of dowry death कहाँ पर है? In section 113 B में, this was abetment to suicide in 113A. Burden of proof as to particular fact, ये है 103 में. अब ये थे इंडियन एविडेंस एक्ट में. अब भारतीय साक्ष्य अधिनियम में सेक्शन कौन से हो गए हैं? ये 103 हो गया है, 106 और 112 हो गया है 116. This is 117. This is 118. All right. Next 33. As per section 31 of Indian Evidence Act, admission are not conclusive proof of the matter admitted, but they may operate as estoppel. 1 is the answer. Now in Bharatiya Sakshya Adhiniyam, section is 25. Next 34. Which of the following section of Indian Evidence Act states that no confession made by any person while in custody of police officer, unless made in immediate presence of magistrate, shall be proved against such person? Which section is this? This is section 26. 3 is the answer. Now in Bharatiya Sakshya Adhiniyam, the section has become section 23. Next is 35. With reference to provisions of section 8 of Indian Contract Act, the performance of condition of a proposal or acceptance of any consideration for a dash which may be offered with a proposal is an acceptance of the proposal. It is reciprocal promise. 2 is the answer. The section is already mentioned. Next 36. BOC debt that is guaranteed by A, the debt becomes payable. C does not sue B for a year after debt has become payable. With reference to section 137, select the correct option. A is discharged from his suretyship. No, A is not discharged. 2 is the answer. This is illustration in section 137. 2 is the answer. Next 37. With reference to the Indian Contract Act, the liability of surety is coextensive with that of principal debtor. 3 is the answer. And this is mentioned in section 128 of Contract Act. Next is 38. As per section 19 of the Indian Contract Act, when the consent to an agreement is obtained by coercion, the agreement is voidable at the option of the party whose consent was so caused. So 3 is the answer. So simple questions and repeated questions. You might have seen these questions in previous year papers of some different state exams. Next is 39. With reference to Indian Contract Act, read the illustration and select the correct option. A promises to B to drop a prosecution which he has instituted against B for robbery, and B promises to restore the value of the things taken. Whether this agreement is legal? No, it is void as the object is unlawful. 4 is the answer. And which section is this? This is section 23 and illustration H. Next is 40. A sells B an unsound horse in an auction. A says nothing to B about the unsoundness of the horse. Whether this is fraud? As per the Contract Act, this is not fraud. Mentioned in the illustration in section 17. So this is not fraud on the part of A. 3 is the answer. Next is 41. With reference to Indian Contract Act, read the following statement and select the correct option. Statement A is consideration is not necessary for creation of agency. Yes, it is correct. It is mentioned in section 185 of the Contract Act. Then authority of agent must always be expressed only. No, it can be implied also, as mentioned in section 186 of Contract Act. Then C, an agent is bound to tender proper accounts to his principal on demand. This is correct, as mentioned in section 213 of Contract Act. So A and C are correct, but B is incorrect. 3 is the answer. Next is 42. A leaves a cow in the custody of B to be taken care of. The cow gives a birth to a calf. With reference to section 163, select the correct option. B has to deliver A both cow and calf. This is correct. No to deliver calf, no. Deliver either calf or cow, no. Can sell both, no. So 1 is the answer. This is illustration in section 163. Next is 43. As per section 11 of SRA, a contract made by a trustee in excess of his power or dash cannot be specifically enforced. So in breach of trust, 4 is the answer. Section is already mentioned here. Next is 44. Which of the following is covered by section 36 of Specific Relief Act? Injunctions, obviously. 1 is the answer. Next 45. With reference to Specific Relief Act, select the correct pairing of section and the titles. Section 38 is perpetual injunction when granted. So this is wrong and this is also wrong. 39 mandatory injunction, this is correct. Injunctions, what is 37? It is temporary and perpetual injunctions. Damage in lieu of or in addition to injunction is section 40. When refused, 41. So 3 is the answer. Next is 46. With reference to Specific Relief Act, select the correct statement. The court may rescind the contract where the contract is voidable or terminable by defendant. No, it would be by the plaintiff. Contract has been ratified by third party. No, jointly no. 2 is the answer. Section is section 27 and mentioning clause C of Specific Relief Act. Next is 47. With reference to Specific Relief Act, read the following statement and select the correct option. Where the instrument is evidence of different rights and different obligations, the court may cancel the entire instrument. No, not the entire, in parts. Mentioned section 32 of Specific Relief Act. This is wrong. Where the instrument is evidence of different rights and different obligations, the court may in proper case cancel part and allow it to stand for the residue. It means A and B are contradictory statements, only one can be true, so B is true. Then where the instrument is cancelled, the court may require a party to whom relief granted to restore benefit which may have received. This is correct. This is mentioned in section 33. So B and C are correct. 3 is the answer. Next is 48. With reference to Hindu Succession Act, read the following statements and select the correct option. A murderer is disqualified from inheriting the property of a person murdered. This is correct, mentioned in section 25. Then B is, if an intestate has left no heirs qualified to succeed to his or her property, such property shall devolve on the government. This is correct. Mentioned in section 29. It is called as escheat. When there is no heir, the property goes to government. So both are correct. 1 is the answer. Next is 49. Which of the following section of Hindu Succession Act deals with general rule of succession in case of Hindu males? Section 8. 3 is the answer. Next is 50. As per section 3 of Hindu Succession Act, one person is said to be dash of another if two are related by blood or adoption, but not wholly through males. Matlab, by female is cognate. 2 is the answer. Mentioned in section 3B of Hindu Succession Act definitions. Next is 51. As per section 14 of Hindu Succession Act, any property possessed by a Hindu female, whether acquired before or after the commencement of the act, shall be held by her as a full owner. 1 is the answer. Simple question from the section. Next 52. As per Hindu Marriage Act, the rules for registration of marriage shall be made by the state government. Obviously, 1 is the answer. Mentioned in section 8 of Hindu Marriage Act. Next 53. With reference to Hindu Marriage Act, select the correct pairing of sections and their titles. 7 is ceremony and 8 is registration. So 2 is the answer. Simple, very simple. Judicial separation is section 10. Void marriages, section 11. Condition of Hindu marriage, section 5. Restitution of conjugal rights, section 9. Okay. Next 54. Section 13B of Hindu Marriage Act deals with divorce by mutual consent. Direct questions. 4 is the answer. Next is 55. As per TPA, condition or limitation absolutely restraining the transfer to any person is void except कहाँ नहीं होती है, गिफ्ट में void है, exchange में void है, pledge में void है. In case of lease where condition is for the benefit of the lesser, तो यहाँ पर जो है वो void नहीं होगी, exception में आ जाएगी. तो 4 इसमें आंसर रहेगा. और ये कंडीशन रेस्ट्रेनिंग एलिनेशन कहाँ प्रोवाइड किया गया है? इन सेक्शन 10 ऑफ टीपीए. नेक्स्ट 56. A transfer is flat to B on condition that B shall marry with the consent of C, D, E. B marries without the consent of C, D, E, but subsequently obtains the consent. With reference to TPA, select the correct option. Whether B has fulfilled the condition? No. B has not fulfilled the condition. 2 is the answer. This is illustration B in section 26 of TPA. Next question number 57. As per section 6 of TPA, which of the following can be transferred? Interest in the property restricted in its enjoyment to the owner personally. क्या ट्रांसफर हो सकता है? No. Any immovable property transfer हो सकती है. Mere right to sue? No. Public office? No. So 2 is the answer. Section is mentioned already here. Next 58. As per section 15 of TPA, if on a transfer of property an interest therein is created for the benefit of a class of person with regard to some of whom such interest fail by reason of any of the rule contained in section 13 and 14, such interest fails. With regard to whole class या फिर those person only या फिर regard transferee या transferor? It is regard to those persons only. 2 is the answer. Section is already mentioned, section 15. Next is 59. As per section 24 of the Indian Registration Act, where there are several persons executing a document at different times, such document may be presented for registration and re-registration within how many months? 4 months from the date of the each execution. 2 is the answer. Next is 60. Which of the following section of Registration Act deals with compulsory and optional registration respectively? Everybody knows 17, 18, very common question, very easy question. 3 is the answer. Next is 61. As per section 17 of Negotiable Instruments Act, where an instrument may be construed either as a promissory note or a bill of exchange, the holder may at his election treat it either and the instrument shall be treated accordingly. Such an instrument is called, what it is called? Ambiguous instrument. 2 is the answer. Section is already mentioned here. Next 62. With reference to Negotiable Instrument Act, a promissory note, bill of exchange or a check payable to order is negotiable by the holder by actual delivery, a delivery actual को constructive endorsement या फिर constructed only. Endorsement and delivery thereof. 3 is the answer. Next 63. As per section 100 of Negotiable Instrument Act, if a promissory note or a bill of exchange has been dishonored by non-acceptance or non-payment, the holder may within a reasonable time cause such dishonor to be noted and certified by notary public. Such certificate is called, it is a protest. 4 is the answer. Next 64. Provision for compensation of dishonor of promissory note, bill of exchange, check is laid down under which section of the NI Act? It is section 117. 1 is the answer. Next 65. With reference to section 6 of the Negotiable Instrument Act, a check is drawn on specified banker and not expressed to be payable otherwise on demand, and it includes truncated check and check in electronic form. What it is called? It is, check is a bill of exchange. 1 is the answer, mentioned in section 6 itself. Next is 66. As per section 4 of NI Act, which of the following note a promissory note? Now in section 4 there are several illustrations are mentioned, and it is mentioned from that A to C are a promissory note and from C to D are not. So these are illustrations itself. And it is asked which is not a promissory note. I promise to pay B or order 500. Means it should be unconditional. Okay. Second is I acknowledge myself to be indebted to B in rupees 1000 and to be paid on demand for value received. This is also unconditional. Then I promise to pay rupees 500 and all other sum and that shall become due. This is not unconditional. So this is not a promissory note. Mr. B, I owe you 500 and I promise to pay on demand. Unconditional hai, so it is a promissory note. So 3 is the answer in this. Next 67. As per Juvenile Justice Act, the Juvenile Justice Board shall consist of Metropolitan Magistrate or Judicial Magistrate First Class, at least 3 years of experience. Yeah, it is mentioned 2 here, 5, 3, and 2 social worker, one of which shall be a woman. So 3 is the answer. Where it is mentioned? It is mentioned in section 4 of Juvenile Justice Act. Next 68. As per section 27 of Juvenile Justice Care Act, Child Welfare Committee shall be appointed by who appoints? State government. 2 is the answer. Next 69. As per Juvenile Justice Act, abandoned child means a child deserted by his or her biological, adopted or guardian, whoever abandons. So 4 is the answer. Next 70. As per Juvenile Act, a child in conflict with law means a child allegedly or found to have committed an offence and who has not completed dash on the date of commission of the offence. 18 years. 1 is the answer. And where it is mentioned? It is mentioned in definition section 213 of Juvenile Justice Act. Next, 71. The general principle to be followed in the administration of Juvenile Justice Act are laid down in which section? In section 3. 3 is the answer. Next, 72. Section 10 of Limitation Act deals with suits against whom? Trustee and the representatives. 4 is the answer. Yeah, direct questions. Next is 73. The period of limitation according to schedule of limitation for suits by mortgagor to recover possession of immutable property shall be 30, 20, 12 or 10. It is 30 years from date of right to redeem or recover accrues. Okay? It is for the mortgage. Na? So 1 is the answer. And which article mentions it? Article 61. Clause A mentions this in Schedule of Limitation Act. Next, 74. Section 6 of Limitation Act deals with, everybody knows, legal disability. 3 is the answer. Very common question. Next, 75. Period of limitation as per Section 2 of Limitation Act means period of limitation prescribed for any suits, application and appeal. 4 is the answer. Next is 76. Under which section of Indian Easement Act can the suit for disturbance of easement be filed? Under section 33. 3 is the answer. Very common question. Next, 77. With reference to section 37, read with section 10 of Indian Easement Act, read the following illustration and select the correct option. A mortgages his land to B and lawfully imposes easement on land in favor of C in accordance with the section 10. The land is sold to D in satisfaction of mortgage debt. Whether easement is extinguished or released? No, it is not extinguished. 2 is the answer. Next is 78. A mortgages a house valued at 20 lakh to B at 10 lakh. B afterward buys the house from A. Stamp duty is payable on dash as per the provisions of Stamp Act. Now see, this is a trick question. He says mortgages. First A mortgages to B. Then afterwards sold to B. Understand? So the mortgage was for 10 lakh. So stamp duty was paid on 10 lakh at earlier. Okay. Now the value is 20 lakh, which B buys from A. So 20 lakh less the amount of stamp duty already paid for the mortgage. 4 is the answer. Since stamp duty has already paid on the mortgage, so obviously it is value on that house. So it should be deducted from the main amount. 4 is the answer. Next, 79. With reference to protection of women from domestic violence for the purpose of determining whether any act or omission, commission, or conduct of respondent constitutes domestic violence under the act, select the correct option. Intentional respondent shall be taken into consideration. No. Socio-economic condition of the respondent shall be taken into consideration. Overall facts. No. So overall facts and circumstances shall be taken into consideration. Yes, everything should be taken into consideration. 4 is the answer. Where this is mentioned in section 3, definition, and there is an explanation. It is mentioned in the explanation. Next, 80. With reference to protection of women from domestic violence act, if a protection officer fails or refuses to discharge his duties as directed by the magistrate in the protection order without sufficient cause, he shall be punishable with for an imprisonment term up to 1 year only, a fine up to 20,000 rupees or both. 3 is the answer. It is mentioned in section 33 of the Protection of Women from Domestic Violence Act. Next is 81. With reference to Protection of Women from Domestic Violence Act, select the correct pairing sections and their titles. So section 18 is Protection Order, 19 Residence Order. This is correct. Others are wrong. So 1 is the answer. Next, 82. With reference to Probation of Offenders Act, read the following statements. The court directing the release of an offender may direct him to pay compensation and cost as it thinks reasonable. It is correct. Report of probation officer shall be treated as confidential. Both are true. 2 is the answer. Next is 83. With reference to Andhra Pradesh Excise Act, read the following statement and select the correct option. If a license or permit is cancelled or suspended under Section 31 of the Act, no compensation or refund of any fee will be made. This is correct. If the license is withdrawn, probation fee shall be refunded. Yes, it is correct. So both are correct. 4 is the answer. Next, 84. Chapter 8, Section 51 to 62 deals with detection, investigation and trial of the offences. 2 is the answer. Appeal and revision is chapter 9 and sections are 63, 64. Offence and penalties is chapter 7, section is 34 to 50b. License and permit is chapter 6 from 28 to 33. Alright, you must learn this because they always ask these questions. Next is 85. As per section 215 of AP Excise Act, foreign liquor includes liquor imported in India other than Indian liquor. Work very simple. Even if you don't know, wherever Indian liquor is mentioned, it is obviously it is not a foreign liquor. Next, 86. As per AP Excise Act, who is authorized to establish distillers and warehouses? So, Inspector of Excise या फिर Excise Superintendent या फिर Commissioner with the previous sanction of the government. 3 is the answer. And which section is this? This is section 16 of AP Excise Act. Next, 87. Which section of AP Excise Act prohibits employment of children and persons suffering from contagious disease to be employed by license holder for the purpose of selling intoxicants? This is section 19. 3 is the answer. What is 18? Duties of licensee with regard to measurement and testing. 20 is closing of shops for preservation of public peace. 21 is excise duty / countervailing duty on excisable articles. Okay. Next is 88. Every offence under AP Gaming Act is cognizable and non-bailable. 3 is the answer. Where it is mentioned? It is mentioned section 5 of AP Gaming Act. Next, 89. As per AP Gaming Act 1974, who is found gaming in a public street or thoroughfare, any public place, shall be punishable with only imprisonment for a term up to 3 months or imprisonment for a term up to 3 months or with fine or both. 2 is the answer. Section is 9 in AP Gaming Act. Next is 90. Which section of AP Land Encroachment Act states that decision as to the rate or amount of assessment, rent or fee payable under section 3 shall not be questioned in any civil court? This is section 4. 1 is the answer. Section 5 is liability of person unauthorizedly occupying land. Then 6 is prior notice to a person in occupation to summon eviction. 7 is again prior notice to person in occupation. Alright, summary eviction. Next is 91. As per Rule 21 of AP Civil Rules of Practice 1990, every pleading or other document filed in court shall bear a date only on which signature of parties are fixed, or if it is filed, या फिर on which signature of parties are fixed, and date presentation and date of filing in court. 3 is the answer. Next is 92. With reference to AP Civil Rules of Practice, interlocutory application means an application in court in any suit, appeal or proceedings already instituted in such court other than proceeding for execution of decree or proceeding for orders only, or proceeding in suit against government or representative suits in execution of decree. 1 is the answer. Where it is mentioned? It is mentioned in definitions in Rule 2J. Next, 93. As per Rule 30 of AP Civil Rules and Practice, Wakalatnama should be in form 12. 1 is the answer. Very simple question. Mentioned in chapter 3. Advocates and representative agents. Next is 94. With reference to AP criminal rules of practice and circulars, read the following statement. In cases prosecuted by the police officer shall not as a rule be employed to interpret the evidence of a witness. This is correct. Mentioned in Rule 56, and it is mentioned police officer shall not to interpret evidence. B is for offence punishable with death, imprisonment, life. An advocate with not less than 2 years standing can be appointed to defend the accused. This is wrong. Mentioned in Rule 36, there are 2 categories I mentioned, Category 1 and Category 2. So death and imprisonment in Category 2 and not less than 5 years standing can be appointed to defend the counsel. So 1 is the answer. Next is 95. Rule 79 of AP Criminal Rules of Practice. Sessions judge and magistrate shall maintain a diary in administrative form number dash to record proceedings of each day. Form number 11. So 3 is the answer. Next 96. As per AP Criminal Rule of Practice, the judgment in appeal shall contain the particulars in a tabular statement in administrative form. 75. 2 is the answer. Where it is mentioned? It is mentioned in Rule 107. Next is 97. As per AP Criminal Rules of Practice and Circular, summons issued to accused shall be signed by a magistrate of chief ministerial officer or court master. Magistrate. 1 is the answer, mentioned in Rule 8. Next is 98. As per AP Criminal Rules of Practice, summons to a government analyst in food adulteration case shall be signed through the High Court or Court of Session or Chief Judicial Magistrate. 4 is the answer, mentioned in Rule 18. Next is 99. As per AP Criminal Rules of Practice and Circulars, orders under Section 167 of CRPC for remand of the accused shall be made on production of diary alone or accused and diary both. 3 is the answer, mentioned in Rule 25 of AP Criminal Rules. Alright. Next is 100. As per AP Criminal Rules of Practice and Circular, the panel of advocate to defend the accused prepared by session judge shall be known as advocate panel or court panel. It is state brief panel. 3 is the answer. Where it is mentioned in Rule 36. So friends, here we have discussed all the questions of preliminary exam paper of Andhra Pradesh Judicial Services 2024. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो इसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़ एंड मैक्सिमम टू 10,000 रुपीज़. तो काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.